Registrations that you got in, did anyone say whether they were going to be, or did you send the link? Okay, they sent the link then to
Renee?
just email me.
There's a question about, was there a differentiation of what you wanted to do online versus live?
So everyone got the email saying we encourage you to attend, take the handouts, refreshments, the email that I sent you, and but here's the link to watch it.
Okay, so everybody that signed up for the evening got the link.
Regardless. And it linked to that.
Oh, perfect.
Opening slide, even though it's not broadcasting or whatever, you know, 2 days ago, it showed me what's coming up.
Oh,
We had some cool type of slide in there.
Yeah, because we had to set it up, so I know Sean sent the link, so I'm not sure what.
But anyway, when you click on it, you get the opening slide. So
Yeah, this is a red.
Got it.
So it's a little bit complex, but I think we're going to get started regardless.
everyone will get a link.
Thank you.
It'll probably be different link, it'll still be a YouTube link, but it'll be, this is the stream link, and then once you record this, it'll give it a different link.
Hi, everybody. It's a little bit after 6, so I think in respecting everybody's time, we'll get started. We are also live streaming on YouTube with tonight's presentation, so it will be recorded. So if you miss anything, or we're going to send everybody the link of the recording from tonight. So my name is Kathy Hinkleman. I'm the Nursing and Senior Services Supervisor for the Village of Schaumburg, and on behalf of the Support Our Seniors Council, who is presenting this tonight, I'd like to welcome you. So I'm very glad you guys are here. We also did a presentation this morning, and it went very well. We have two presenters tonight. We have Lauren Weldon, and Lauren is a partner at Margolis Weldon LLC in Park Ridge, Illinois. She founded the law firm with Matt Margolis in 2015. She graduated from the University of South Carolina with a BS in 2005, magna cum laude, and she obtained her law degree from the John Marshall Law School at the University of Illinois, Chicago, also magna cum laude, and that was in 2011. And her Juris Doctor certificate of concentration in elder law in 2011. She is a member of NAELA and the Elder Council. She focuses her practice in the areas of estate planning, long-term care, Medicaid planning, and trust administration. Lauren's career as an elder law attorney has allowed her to help a growing segment of the population with their unique needs. Lauren was raised in Des Plaines and currently lives in Mount Prospect with her husband and 6 children. Our second presenter is Kathleen Bolger, and Kathleen is a caregiver specialist at Kenneth Young Center. She assists individuals and families who provide unpaid care to loved ones by facilitating support groups, counseling, future planning, and caregiver respite services. Kathleen was a caregiver to her parents. Previous to this, Kathleen worked in musical theater and news media content licensing and sales. She has a Bachelor of Fine Arts in Music from Carnegie Mellon University and a master's degree from the University of Chicago School of Social Service Administration, where she focused on clinical gerontology social work. So with that being said, let's welcome Lauren Weldon.
This part up. This is the logistics. It's like super tiny. Here. Yeah. I think so. I know, right? Can everyone hear me? Yeah? Okay, good. Welcome, and thank you all for coming. I'm Lauren Weldon, and I'm excited to be back for round 2 tonight. As you heard, the morning went so spectacularly that they invited me back. I feel like I have, to live up to the hype tonight, though, especially because it's being recorded. Today, we're going to be talking about proactive planning. So one of the things that frequently I see as an elder law and estate planning attorney is people come to me and it's a crisis, right? So somebody is sick. Someone has just passed away. There's an issue at the bank. The bank won't accept the power of attorney. Or a mom's doctor thinks that she can't drive anymore. There's some issue that someone says we need to go see the attorney for, okay? The people who come to see me in crisis fall into 2 main categories. There's the people who have their documents and they don't have a plan. So they put documents together and they thought that that was enough, right? So they put them together and they put them in a binder and they put them on a shelf and they don't even know where it is. Or they put them in a safe deposit box and I'm pretty sure I have them and I told the kids I have them. And as children you say, my parents told me that I have them, but nobody really knows where they are, or what they look like, or what they even are, right? Nobody knows anything about them. That's one group of people. And the other group of people is the group of people who haven't done any planning. For whatever reason, no judgment, there's no planning done. But either way, we find ourselves in this crisis position where we need some guidance to get ourselves in a better place, okay? So today on our agenda, we can go forward from there. On our agenda, we're gonna discuss a few things that I think are super important for you to understand to make sure that you're more proactive and prepared than the common folk, okay? So the first one that I want to talk about is a subject that's near and dear to my heart. I think it's probably the most important thing that I can impress upon you today, frankly, and that's powers of attorney. So powers of attorney are the most important estate planning documents you can get or not get, as the case may be. They're more important than trusts or wills or anything else. Powers of attorney are crucial. Sometimes clients come to me and they say, when we start going through the estate planning process and they have to make decisions and the decisions are getting difficult or the conversation's uncomfortable, people will say, well, what does it really matter? I won't be here anymore. Who cares where my money goes? It's not going to affect me anyways. Powers of attorney are going to affect you. They're going to affect you when you're sick and when you need somebody to help you the most. They're going to affect you and your family because their family won't have the tools necessary to be able to communicate with a doctor or make healthcare decisions for you. They're going to affect you because nobody can pay your bills or access the IRA or talk to your attorney or anyone else on your behalf. Powers of attorney affect us in a very real way. So having those in place is super important. If we don't have powers of attorney, then we're faced with this process called guardianship. And I'll go into some detail about that. Guardianship is a process of last resort. It's not where anyone wants to be. It is a process where we have to go to court and have a guardian appointed because we didn't put powers of attorney together and we didn't do any planning ahead of time. And now we've reached a point where we're incapacitated and planning is no longer an option. After we get past the guardianship piece, I want to talk about trusts and wills. Trusts and wills are part of estate planning. And they're an important part of estate planning. In common terms, right? I was listening to the radio the other day and Taylor Swift's out there and she's singing about wills, right? So she's she's in pop culture, everybody knows who she is, right? And she's out there and she's singing songs about wills. So as a people, we know what a will is. We've heard of wills and we understand somewhat that they help us transition wealth to our heirs after we pass. Most people, though, have some misconception about what a will actually does and what a trust does and whether or not they're appropriate for you or not. Okay, so we want to go into some details about that. One of the biggest things that I see that can derail an estate plan, and I see it frequently, is the concept of unintentional estate planning. We want to be intentional about our estate planning. We want to know what we're doing and we want to make decisions that are going to be the best for us and our families. We don't want to do things because we're looking for a Band-Aid or thinking I'm going to have surgery tomorrow, so I'm going to go ahead and just, I don't know, I'll put my sister on as a beneficiary to this account, or I'm just going to add, my one son on this as a joint owner because if I need to pay bills and I'm hospitalized and I can't get to my checkbook, he's the one that lives closest and he can help me with it. Those decisions have real consequences, and those consequences can last way longer than that little time when we were sick or we were in the hospital or we were just going to go on vacation, right? So we want to be intentional about our estate plan. The last thing I want to talk about is long-term care considerations. I could come up with the best estate plan for you that money can buy, and then I'll have all the bells and whistles, but it won't actually do anything if there's nothing left to give to your beneficiaries. Right? If we spent it all on our long-term care costs, what's the point? So making sure that we incorporate long-term care considerations into our planning is going to be super important as well. All right, let's get started. So as I said before, powers of attorney are the most important documents you can have. Anyone over the age of 18 in Illinois can create a power of attorney. I frequently have parents contact me and say, my 18-year-old is going off to college and I want powers of attorney in place. I want to make sure that if something happens, the doctors will talk to me because otherwise they don't have to. And that from a practical standpoint, they want to be able to get their kids' grades. If they are failing out, they want to know. And the only way to do that is to get the appropriate documents in place before we set our children off into the world. So powers of attorney are appropriate and needed for anyone over age 18 in Illinois. In order to execute a power of attorney, you have to have capacity. Just because you have a diagnosis of dementia or another cognitive ailment that might affect our capacity doesn't necessarily mean you lack capacity. Capacity is a spectrum. So depending on where you fall on that spectrum, we may still be able to execute powers of attorney. If you don't have capacity, then we're in a situation where we have to talk about guardianship. There's two types of powers of attorney in Illinois, a property power of attorney and a healthcare power of attorney, and you need both. Sometimes people come to me and they have a healthcare power of attorney that they've executed in a hospital. Usually it's in a crisis, usually it's when they're not feeling all that great, and they frequently appoint the person who brought them to the hospital. That person may not be our best choice, but it's a little awkward to choose anyone else because after all, someone just brought you to the hospital in your time of need, so it would seem rude to not choose them. That's not a good estate plan though, right? So when we're thinking clearly and we're not in a crisis, that person may not be our best choice as agent. A property power of attorney will allow us to make financial decisions. So it encompasses more than just property itself. It's all financial decisions, whereas healthcare decisions are governed by the healthcare power of attorney. The power of attorney document is where a principal is appointing an agent to make decisions for them. So the agent steps into the principal's shoes to make those choices as if they were the principal. This is important to know because it's different than a separate entity that you would take on. It's not a separate role. You're literally stepping into the shoes of the principal to make decisions on their behalf. This is crucial because this limits your liability as the agent to whatever the principal would be liable for, okay? It is important to understand that there are certain witness requirements for powers of attorney. I have people come to me sometimes with powers of attorney that they've executed themselves, and the most common reason why those powers of attorney don't work is because they've chosen a witness that does not comport with the law. When we need something done, we usually rely on the people who we can kind of con into doing things for us, right? And those people are usually our family members. Our family members who might be related to us by blood or marriage. You can say, everyone come over, let's have dinner, I'll get pizza, and we'll execute our documents, right? We'll have an execution document party. Those are not good witnesses. They don't qualify as good witnesses under the law. We want people who are not subject to be manipulated by you as your witnesses, right? Otherwise it's questionable authority as to whether or not you really wanted this person to act, right? Because we have these witnesses who are not exactly independent. So we want independent witnesses to witness the documents. Neighbors or friends work really well. The property power of attorney requires a notary, whereas the healthcare POA does not. So healthcare powers of attorney are more easy to obtain. Doesn't necessarily mean that they are done correctly or with the appropriate thought in mind when we've gotten them, but they're more easily obtainable for that reason. Powers of attorney can be effective either immediately when you sign them or springing, meaning some point in the future. It's important to look at the document to see what you have if you have a power of attorney, and it's also a really important decision to make with your estate planning attorney and family. It's not a one-size-fits-all kind of a thing. There's pros and cons as to why you would choose one versus the other. Sometimes we want to make the power of attorney immediate because we are appointing our spouse, and a lot of our assets are joint anyways, and it just makes life easier to have that authority immediately. Sometimes though, because we're giving keys to the kingdom to, let's say, a son, I don't know if I really want my son having access to all of my financial assets and ability to sign my name and engage in estate transactions on my behalf starting now. I may want to wait until I'm incapacitated or a doctor says I can't make my own decisions. There's pros and cons to that decision too, right? So if I maybe can't go somewhere, this happened a lot during COVID when a lot of people were in facilities and communities where they were on lockdown, they couldn't leave. If they had a power of attorney that was springing, it wasn't effective immediately. Their children weren't able to use it to transact business on their behalf. So it really is an important decision to make, and you have to weigh the pros and cons to figure out which is the right choice for you. All right, let's talk now more in detail about the property power of attorney. So the property power of attorney is the document where we are appointing someone to make financial decisions if you can't. It encompasses more than just real estate or accounts. It also includes the ability to sign the principal's legal name. So signing someone's legal name to a contract to buy a car or a mortgage or transferring real estate out of your name or signing someone up for liability, that's important, right? That's a big deal. You can ruin someone's life with the ability to sign their name. In addition to having the ability to sign someone's legal name and access their finances, you have the ability to make gifts in a power of attorney. So they can be customized to say, I want my power of attorney to be able to do these additional actions on my behalf should they become necessary, like engaging in estate planning or making gifts to people. Those are important aspects of a power of attorney that could help us down the road when it comes to long-term care planning, but they're not to be taken lightly. I can't stress enough that powers of attorney are dangerous tools in the wrong hands. They're necessary documents, but they also will allow someone to do a lot of things on your behalf. And they don't necessarily need to give you notice about doing those things. So it's really, really important that you choose someone that you trust, and that's a trustworthy individual. Your agent under a power of attorney for property is a fiduciary. That means that they are held to the highest standard under the law to act in your best interests. It means they're going to get in more trouble than normal if they do something wrong. But if someone has done something wrong, that means we're kind of chasing after them after the fact, right? The money may be gone by that point. There may be nothing left to get. So it's far more important to take your time and really make that choice thoughtfully as opposed to rushing through it. As I said, power of attorney can be immediate or springing, and it can be customized. It's not uncommon for someone to get a power of attorney for a real estate transaction where they're appointing their real estate attorney to sign the closing documents on their behalf so they don't have to go to the closing. The document that you're signing is a power of attorney. It's a document that limits the authority of that attorney to a specific duration and time and specific actions, but it is a power of attorney. It's just one example of how we can limit that power of attorney or how we can add powers, like as I discussed, adding gifting powers. In addition to the power of attorney actions, the agents don't have to act. So if you choose an agent, sometimes we think, okay, I went through this thoughtful decision-making process and I've named my children and I figured out who's gonna do what and this is how it's supposed to work. But the agent doesn't actually have to do anything. They may decide that it's not in their best interest to act at that time, or they can't, or they may be predeceased or incapacitated themselves. So it's super important for both the healthcare and property power of attorney that we explain to not only the primary agent what we want regarding our finances or healthcare, but also the subsequent agents. We tend to stop at the first one and say, this is the person who's going to do it, because frankly, that's who we want to do it. We named him first for a reason, but it may not be the person who actually makes decisions for us. So that's really important to think of too. Okay, the healthcare power of attorney. So the healthcare power of attorney, as I said, is the document where we are appointing someone to make healthcare decisions for you. There's a belief sometimes that people have when it comes to healthcare choices, and this is because in practicality, if someone is sick and they go to the hospital and they have a spouse, frequently the nurses and doctors will speak to the spouse without any appropriate legal documents in place, okay? They're not supposed to. But we do this because we're trying to solve a problem, and we're in a hospital, and hospitals can get crazy, and we're trying to move people through, and sometimes it's just easier. Doesn't always mean it's right, though. I had a client one time, children called me, he was in the hospital, and his second wife suffered from mental illness, and the hospital continuously called her to make decisions for him. She would make decisions that were contrary to what he wanted, and frankly just contrary to the decisions she had made before. The day before. So it was a huge problem because the people in the hospital weren't looking at the documents. They were just saying, Susie's here, she's always here, she comes and visits him, she seems really nice, I'm just gonna start asking her what we're supposed to do. Susie wasn't in a good position to be making choices for anybody, and the problem was there was no reflection on what was in the client's best interests, right? So I'm not gonna pretend that that we live in a bubble and the documents are always going to work the way that they're supposed to. They don't always work the way that they're supposed to. But they definitely don't work at all if you don't have them, okay? So with a healthcare power of attorney, it's super important that we choose someone to act as our agent who is going to be able to fulfill the duties, just like with the property POA. It's sometimes even more important with the healthcare POA because there's more difficult emotional decisions that have to be made by that agent. And sometimes the person who we want to make those choices isn't actually able to make them. I had a situation where my client appointed his wife as his agent under a power of attorney. And he was in the hospital. He was repeatedly hospitalized because he was pulling out his feeding tube. He didn't want it in anymore. And the doctor and the surgeons were just done. They said, we can't do this anymore. This surgery is going to kill him if we have to keep doing this. And the fact that we are still doing this is not okay. This is unethical at this point. My client's wife couldn't make that choice. She was not a good person to be put in that position. She couldn't do it. She was going to keep going until something else happened that made the choice for her. But as long as she could keep it, the system up, she was going to keep rolling with it. She wasn't a good person to be put in that position, and I didn't put those POAs together, but chances are good that she was never the right person to put in that seat on the bus, right? She was probably never the right person for that. It is really, really important that we take the time and make thoughtful decisions about who can actually make those choices and what the impact of those choices are going to be on that individual. I have clients sometimes who say, I want my child to be the subsequent agent after my spouse. The child will be younger, maybe they'll be 21, 22, 23. And I always say, I really don't think this is a good decision. I think it's a terrible decision. I think if push comes to shove and your son at 23 has to make the decision to pull you off of a ventilator, you're putting a lot on somebody's shoulders who's pretty young and may not be able to weather that. So even though they may be someone that you trust and consider to be responsible and that they love you and you love them and they know what you want, what is the impact of that choice going to have on them for the rest of their lives, right? It's also really important that we are choosing someone who is going to be able to actually execute the decisions that you want regarding your healthcare. We don't all have the same beliefs. We don't all feel the same way about our healthcare choices. We don't all view healthcare the same, and that's okay. You don't have to choose an agent that necessarily agrees with everything that you agree with regard to healthcare decisions, but that agent has to be able to actually make those choices on your behalf, not on their behalf. And sometimes that's not the people that we consider our go-tos, right? Maybe that's not our children or our spouse. Maybe we have different thought processes, and maybe they don't believe in certain things that we do. So they're not good choice. And just because we're sick or in a crisis doesn't mean that they're gonna all of a sudden change, right? The kid that's never been good with money, just because you pass away, isn't gonna get any better with it. The one that doesn't believe this, that, or the other isn't all of a sudden going to believe it just because now you're sick. Those things don't change. We have to acknowledge them for what they are and make our choices accordingly. Sometimes we'll look at that landscape and say, I don't have any good choices. I've gone through my choices and the choices are all not very good. The people who are surrounding me are great and I love them dearly, but they're not going to be able to fulfill my wishes. And so now what? That's a good reason why many people cite to say, I don't do any estate planning because I don't have anyone to choose. I don't have anyone I trust. I don't know what to do about that. There are individuals, companies, there's a whole category of people who specialize in acting as agents for powers of attorney. Healthcare decisions, property power of attorney, you name it. So we can explore alternative ways to fulfill those duties. Sometimes it's a friend or a neighbor who's going to be able, who maybe not be your best friend, right? But they'll be able to follow your guidelines and do what's necessary. And so that's important too. We can look outside of our immediate family to make those choices, as long as it's someone that we trust and that can actually fulfill our wishes. Powers of attorney for healthcare, just like the property POA, can be customizable. What that means is that we can make choices within the power of attorney document. There's a couple of big choices. The first one is when the power of attorney is effective. And this is important because the power of attorney has different choices in it about when it will be effective, right? That springing or immediate choice. Power of attorney for property has 3 choices as to when the document is actually effective. The first 2 both state that it's not effective until a doctor says in writing that you can't make your own decisions, and the last one says that it's effective immediately. It doesn't mean that you can't make decisions, but your agent can also make decisions. A property power of attorney can only be terminated if somebody has capacity. A healthcare power of attorney can be terminated even if you don't have capacity, which is a potential problem Because if you lack capacity and you get mad at your agent because they're doing something that's contrary to what you believe at the time, you can terminate the document and then we end up in guardianship court. So thinking about that is important when we go through this document and this exercise. In addition to making decisions about when it's effective, it can be customizable based on the life-sustaining treatment decisions. So there's two main choices in the healthcare POA. The first one says, I believe that the quality of my life is more important than the length of it. So I want my agent to take into account the quality of my life when making decisions about whether or not life-sustaining treatment should be used. The second one says, keep me alive no matter what. It is important to note that when you execute a power of attorney, don't make that decision lightly. Think about it. Think about it based on how you feel now and how you're likely to feel in the future. If you change your mind, you need to execute a new document. Otherwise, your existing document and the decision you made is going to stand. And if you change your mind and that document doesn't reflect that change, we could have a big problem. I had a client come to me earlier this year who said, my mom is 94 and all the siblings are in agreement. I'm her agent under the healthcare POA. She executed it like 15 years ago. And we are all okay with letting her go. She's really sick. They're talking about hospice. Nothing is good right now. All the siblings don't want to put her through any more suffering. It's time, it's time, it's time. And he said, the problem that I have is that the healthcare power of attorney says that she wants to be kept alive no matter what. She's 94, she has terminal cancer, things are not good for her. I don't have to follow that, do I? I said, actually you do. You do have to follow that. That was her wish. She could have executed a new one. She didn't. So the presumption is that she wanted to be kept alive no matter what. We all would think that probably under the circumstances that she finds herself, she may not still feel that way. But she didn't do anything to change the document. And so the document is a legal document and her choice stands. So if you change your mind, it's important to change the document. All right, now let's talk a little bit before we move on to about the POLST, the HIPAA, and the living will forms. Kathleen is going to talk more in detail about these, so I'm not going to go into too many specifics here. But a living will is something that we hear a lot about, and a living will, frankly, is the least important document that I'll talk about today. It is a healthcare document, but it's really a backup to your healthcare power of attorney. The living will gained recognition because of Terri Schiavo. Everybody remember Terri Schiavo? So Terri Schiavo was a woman who, at a very young age, suffered a medical condition where she wasn't able to make her own healthcare decisions. And she was kept alive for a significant period of time under difficult circumstances until her husband petitioned a court to say, I want to be allowed to let Terri go. She wouldn't have wanted to live like this. Terry's parents said, no, she would want to live like this, and we want our daughter to stay alive as long as she can. She's still with us, and we want to keep it that way. There was some static about what real motivations either party had in that decision-making process, right? What were their real motivations for saying, I want to let Terri go, or I want to keep Terri here? It would have been real helpful if the court had had a document from Terri about what Terri wanted, but they didn't. So they had to go forth and try to piece it together on their own, which was not the best way to do anything. A living will is a statement of someone's intent regarding life-prolonging procedures that says, if I have a terminal irreversible condition, I do not want to be kept alive. Let me go. It would come into play if there was a difficulty, I guess, in the family, and the agent is doing something that other people feel like is contrary to what the POA indicates, right? My client who says, I want to let my mom go, but the POA says you got to keep her here. Somebody, a hospital, a social worker, anyone could say, this is contrary to what the POA says. Is there some other document that we could use to verify mom's intent? If there wasn't another document to verify someone's intent, then we're stuck relying on what the POA chooses to do, which may or may not be in the person's best interest, right? It goes back to the idea of choose someone that you trust. But the living will is that backup document. A HIPAA document is useful because it allows someone other than the healthcare power of attorney to be able to access medical records and speak to your doctors. In many common circumstances in families and friend networks, it's not always the healthcare POA who's driving you to the doctor or bringing you to the doctor or being part of the conversation, or frankly, who shows up at the hospital that day, right? If we want to be able to communicate healthcare decisions and information to more than just the healthcare agent, a HIPAA document is really useful. It's useful also to kind of cool down family dynamics when they get kind of heated up, right? So this allows the other siblings to be able to speak to the doctors and be part of that conversation so that it's not just older brother's view on what the doctor said. Everybody gets to ask questions and be part of that conversation. Only the healthcare POA gets to make decisions, but at least everybody gets to hear, which can be helpful. The POST is a practitioner's orders for life-sustaining treatment. It's the new DNR form. The DNR and a life-sustaining treatment decisions are two sides of the same coin. So they're similar, but they're different. Because of shows like ER and Chicago Fire and all of these shows, we have this belief that a DNR plays a much more vital role in our lives than it really does. There's a pop culture belief that people are running around resuscitating people and there's like paddles and that's very, very emergency driven, right? Everybody's in chaos and crisis. The reality of life-sustaining treatment and making those decisions, it's not like that. It's quiet, it's serene. We've had plenty of time to think about it. It's not a crisis. The DNR piece of things applies when someone is legally not breathing, right? They're deceased and we are bringing them back to life with some intervention, right? The life-prolonging procedures like ventilation or intubation is when someone is alive, but they're not going to stay that way without us doing something to keep them going. One of them happens a lot more commonly than the other. And the DNR piece of it is one that clients come to me frequently and they say, I don't care about any of the rest of the stuff you're talking about, Lauren. I just need a DNR. And I say, okay, well, slowly roll. Let's talk about what a DNR is going to do for you and what it's not. A DNR only applies in that circumstance where A, somebody knows about it, and B, you are suffering an emergency where there's plenty of people, or there's people around to do something to revive you. If you have a DNR, but no one's around when something happens and it doesn't really do anything for you. If you have a DNR and nobody knows about it, it doesn't really do anything for you. The default under the law is to keep you here. If you're mad at us afterwards, so be it. It's a one-way street, right? I'd much rather bring you back and have you mad than make the other choice, because then there's no redo for that one. So if you feel strongly and passionately about the POST form or the DNR aspect of it, then having a conversation with your doctor would be the next important step. The form has to be signed by a physician, and I strongly encourage you to have a conversation with your doctor about the form and how appropriately to fill it out. The problem I have with the POST form is that it's more than a DNR. The top section, section A, is a DNR section, but then the other two sections, B and C, talk about life-prolonging procedures, which is that healthcare agent decision, right? The life-prolonging procedures sections get into some pretty specific detail about what you might want. For example, how many days you want a feeding tube, if one is needed. I don't know. Who knows the answer to that question? I have no idea. You'd have to talk to a doctor, and honestly, I think that they may say that really depends, doesn't it? Depends on the circumstances and what's going on and what's realistic and all that great stuff. I would much rather leave that decision to an agent in a healthcare POA who can take into account real life circumstances. The reason why I don't like the POST form is because you're locking yourself into a decision that may be contrary, and many people don't get guidance when they fill that thing out. They don't get the chance to have a real conversations with their doctor about what's appropriate, what makes sense, and how to fill it out so that you're not choosing not to be ventilated, but that you do want a feeding tube for 12 days. In which case, that may lead to a very contradictory and uncomfortable result. So we should have some thought when we're filling out forms like that. I had a client, I was giving a presentation like this to a group of social workers, and one of them told me that her problem with the POST was that sometimes we fill it out with a very specific set of circumstances in mind. She had a resident, she was working in a nursing home, who had terminal cancer, and she filled it out and she said, I don't want to be resuscitated under any circumstances. I don't want any interventions whatsoever. She was eating lunch one day in the cafeteria and she choked. When she filled that out and said she didn't want to be resuscitated, I have no doubt that she had a very specific plan in mind. She didn't want to be in the hospital, dying of terminal cancer, and have someone resuscitate her under those circumstances. The circumstances that actually occurred were very different. And the resuscitation piece of it wouldn't have necessarily meant that her quality of life would have been so much worse, right? It would have meant that there was more, that we could have saved her life because the choking on a piece of chicken in the cafeteria wasn't what she had in mind when she filled out that form. So it's important to keep that sort of stuff in mind too. Okay, let's talk about guardianship. Oops, I went too far. All right, guardianship. Guardianship occurs when we have not done any planning for POAs, right? So this whole long thing that I've been going on and on about, we never did anything. We said we were gonna and we never got around to it. Or the POA was ineffective because we had our son-in-law come as a witness and then our daughter showed up too that day, right? They wanted the free pizza we were having at the party. So they showed up, they executed the POAs and they're invalid, or we never got any put in place. And now the principal is incapacitated, meaning they can no longer execute legal documents. If that's the case, there's no default that says, well, we are a spouse, so we should just be able to access all of your retirement accounts, even though my name's not on those. Or I should be able to make healthcare decisions for you, because we know what that looks like, right? I gave you the example of my client's wife. The default under the law is that you have to go to court and get a guardianship proceeding opened and get guardianship of somebody who's incapacitated. There's many reasons why we do that, but one of them is because we have people who may not be the best, have the best motivations, who could be accessing finances or making healthcare decisions. So we want this independent person, this judge, to be able to appoint somebody who's going to make good choices for us. So guardianship is where we go to court and we have a judge adjudicate somebody disabled. So as a disabled individual, if I'm deemed completely disabled, I don't have the right to drive or vote. I have no rights to do anything. I can't manage my finances or make my healthcare decisions. Instead, a judge is going to appoint a guardian to make those decisions on my behalf. Somebody hopefully who I know and like is going to petition the court to say, I want to be guardian. It could be somebody that you don't know and don't like who's going to petition the court to be guardian. And the judge is going to appoint what's called a guardian ad litem, who acts as the eyes and the ears of the court, to go out and talk to you as the disabled person and figure out whether or not you want this individual to be your guardian, and whether or not you need a guardian and what your thoughts are, and is this person a good choice. If the GAL says, yes, this petitioner is a good choice, then they will be appointed by the judge, most likely, as the guardian who's going to manage this petitioner, this disabled person's financial and healthcare decisions for the rest of their life. If they don't, or if, let's say, another sibling comes in and says, no, I want to be guardian, then we have to go to hearing, and a judge is going to have to figure out who the best party who is, right? It sometimes happens where the disabled person says, I don't want a guardian. I don't like either of these two yahoos. I don't want them involved, and I don't think I need a guardian. In which case, the judge, we go to hearing, and this starts getting really expensive. The petitioner who originally appointed, so let's say Good Daughter goes in and says, with my attorney, I'm going to file a legal proceeding for guardianship, and I'm going to try to get guardianship of Mom. There's one attorney involved. The GAL goes out and talks to everybody. It's another attorney that they get paid to. Now Mom's saying she doesn't want a guardian. She gets an attorney. So that means we have 3 attorneys involved. They're getting paid too. And now Bad Sister comes in, and guess what? She has an attorney as well. And so now all these attorneys are just racking up bills left and right, and we are just getting astronomically expensive. At the end of the day, Mom's probably going to get a guardian. It may not be either of the 2 sisters, right? There could be a third person who is appointed by the court, because the judge may say, I don't like either of these 2. They're not very good at all. I agree with you, Mom. You need a guardian, but these 2 aren't going to work, so we're going to appoint somebody else. They most likely have an attorney too. All of those attorney's fees are going to be paid by mom's estate. So it can be really expensive to go through guardianship. It's not something that we do lightly. It is a step that we take as a last resort. So if it is possible for us to get a power of attorney in place, that is what everybody would prefer. There is nobody who leaves the courthouse in a guardianship proceeding that says, man, this has brought our family closer together. We are all singing kumbaya. This has been so great for us. It's been so lovely that we've been to spend this time together and spend all my mom's money in our inheritance. No, nobody says that. It tears families apart in a major way, because every single tiny spat that you had when you were 4 is coming back up, because now we have this neutral decision maker and the floor is yours, right, ladies? They're gonna go up there and really duke it out about all those things that they didn't like about each other, and mom isn't really in a position to act as the mediator anymore. It is also used as a process when our power of attorney was appointed and that power of attorney is abusing their authority. I had a situation when it was years ago, and it was winter, and I was visiting my client who was in the hospital. We were starting the process of updating her documents because her daughter was just terrible, and her daughter was just not somebody who my client wanted to make decisions for her anymore. She was just mean to her, and we just needed to get her out of there as the agent for healthcare and finances. So we started the process, and then she ended up getting sick, and so I went to go try to visit her at the hospital. And I remember it was winter, and hospitals are always so hot, right? And I was wearing my winter heavy coat, and I was pregnant, and I finally made it to her room, and I was like huffing and puffing, and I went to say, okay, I'm about to go in this room and talk to my client. And this nurse steps in front of me and says, "Who are you?" And I said, "I don't have time for you right now, lady. I'm really hot, and I'd like to go sit down and talk to my client. I'm her attorney." And she said, "What's your name?" And I gave her my name. And she said, "You're not on the list." And I said, "What are you talking about?" And she said, "There's a list, and you're not on it. The only people who can see your clients are on the list." So needless to say, I was really mad when I got back to my car. I was real hot at that point and very frustrated. And I proceeded to try to call my client. And I called her cell phone, didn't answer. I called the hospital room, and a different nurse answered and said, "What's your name?" And I said, "I'm Lauren Weldon." And she said, "You're not on the list." And I was pretty angry. So I went back upstairs, and I was saying all sorts of things about, malpractice. I'm going to be in trouble for this, and you're all going to be in trouble for this because you can't bar my client from seeing me. And where's your risk management? Where's the supervisor? All hot to trot. And her financial advisor apparently had a meeting with my client right after me. And he comes up and he's like, "Can you get in to see her?" And I said, "I can't get in to see her." And he's like, "I can't get in to see her either." So we're all standing there, all upset. And then finally somebody goes talks to their risk management team, and they let us in. And my client is like, "Where have you been? I've been sitting here for hours. I can't find my cell phone. No one has called me in 2 days, and all the people who told me they were going to come see me haven't shown up." And we were like, "Laverne, we have a story to tell you." It turns out your daughter has barred just about everybody under the sun, except her and her son, from being able to speak to you or see you, which is why we needed to get her out of the picture, right? So it is not implausible that our agents may let their power go to their head and do something like what Laverne's daughter did, right? So she didn't want anyone else to see mom because she didn't want anyone else putting any ideas in mom's head about what daughter was doing or what needed to be changed regarding documents or anything else. And she certainly didn't want the two of us, right, financial advisor and me, coming in there and trying to change any paperwork. So she was not happy about it. It's a lesson for you all, right, about who to choose when you are making your agents. All right, wills and trusts. These are super important documents, and I'm going to go through them relatively quickly so we have a little bit more time because I know Kathleen's going to get up here soon. Wills and trusts are traditional estate planning documents, and the way that I like to describe them as like they're two separate jurisdictions, they're two separate countries, okay? We've got the country that the will lives in over here, and then we've got the trust country over here. The two main players are just like presidents of countries, right? Kings. They manage their area, their geographic area. So for a will, the executor is the person who manages the estate. We have a trustee who manages the trust. The trustee can't do anything regarding the estate, and the executor can't do anything regarding the trust. Okay? The wills and trusts differ from the property POA because the property POA, just like the healthcare POA, stops working after you pass away. This makes sense, right? We don't need to make healthcare decisions for you if you're not here. But with a will and a trust, they span a time period after somebody either becomes incapacitated or after they pass away. So the POA is out of the picture, and now we're talking about wills and trusts. The will is the more common document that we associate, right? Taylor Swift's singing about it when we think about estates. A will is a document that we would give to a judge that dictates who is going to be our executor, who we've chosen to act on our behalf, and where our money is going to go through the probate process. A will does not get us out of probate. Sometimes people come to me and they say, my mom has a will. What are you talking about probate? We shouldn't have to go to probate because there's a will. That's not true. A will is just a letter to the judge that helps the judge figure out where you want your stuff to go and who's going to help make that happen. That's it. The will only operates after somebody passes away. Sometimes clients come to me and they bring their children start saying, well, I'm the executor. Well, mom is sitting right with me, so you're not the executor because mom is still with us. So you're merely named in a document as her executor if and when she passes. An executor is also not formally given that role until a probate estate is opened with the court. So a judge has to bestow that authority on you. Even if you're named in a document and someone passes away, you don't get to go out there and start making decisions and accessing money and selling real estate until a court appoints you as the executor and an estate is open. So we have to go through that process if we have a will or if we don't have a will. So for individuals who don't have a will, we have a solution for that, because this whole process of people passing away and having to distribute money has been going on forever, right? So we have this statutory hierarchy as to who gets to your money if you pass away and you don't put a will together. People are usually not super happy about the way that hierarchy goes. So if I passed away today without a will, half of my money is going to go to my husband and the other half of it is going to go to my kids. My husband's going to say, they don't need it. I need it to take care of them. They don't need more Barbies and Legos, right? I need it to pay the bills. He's only getting half. That is usually not the result that we want. So that's where the will comes in, right? That's where we say, I don't like that result, so we're going to put a will together to change it. The probate process is, think of it like going to California on a freight train. We're going to get there. It's going to be loud. It's going to be dirty and dusty and uncomfortable. It's going to cost us more than we want. It's going to take forever. But we'll get there eventually. Having a trust is more like going to California on a plane. It's a lot nicer of a journey, right? So most people, when they go through probate, tell themselves and everyone else who was even remotely willing to listen, they don't ever want to do that again. It was terrible. It's not that the process itself is terrible, is that it is a bureaucratic process. It moves really slowly, and you got to deal with a bunch of people and clerks and judges, and you got to get a court date, and you got to talk to the attorney, and you need this in a form, and then that form isn't right, you got to get a different form, and the whole process is just not very user-friendly. It does work. It's been working for hundreds of years, and so it helps us, especially in cases where either we want that neutral decision maker, so we want a judge to be there to make sure that no one's running off with the money, or in cases where we just don't have anyone else to step in and act for us. Many people say, though, I want to avoid probate, so let's put a trust together and that will give us a better result. And for many people it does. A trust is a separate entity where we are putting assets into it so that it will continue after we're gone. If I pass away and I'm no longer here or able to transfer my assets to anybody, then we have to go through probate, right? Because nobody else has the legal authority to sign my name. With this bucket, this trust that we've created, I'm appointing other people, successor trustees, to be able to access my assets and distribute them based on the terms of the trust. Since it's a separate entity and it's not that I own these assets anymore, but my trust does, when I pass away, it doesn't affect my trust. The trust says, we presumed she'll pass away eventually, and we're going to say that now the successor trustee can step in and take over the duties of trustee and manage the assets appropriately and distribute them for the beneficiaries. We don't have to go to court. We don't have to get any letters of office. We don't have to deal with any of that stuff. It gives a lot more control and flexibility to the successor trustee to manage those assets based on circumstances at the time. Sometimes it's helpful if we have someone living in the house where we say, I don't want to get them out right away, right? Let's say I had a situation where I had a daughter that was living with her mom for a very long time, and the other children said, it's okay, she's going to need time to get out. We're not in a rush to sell it. It ended up being 3 years later, so the rush was really not a rush, but we're finally wrapping that one up. And that was okay, because the family said, the daughter as trustee said, it's okay, I don't want her to go right now, and everybody's in agreement, and I have that flexibility. A judge would not be down with that, right? Like, a judge would say, we need to keep this moving, guys, so let's sell the house and move this along. I've got a court docket to manage. So it gives more flexibility to the individuals in the trust and the trustee to manage things. So that's why it's preferable in some circumstances. The most important thing, though, I want to mention about a trust is that it has to be funded for it to work properly. With a trust, we always do what's called a pour-over will. And the pour-over will is a backup to the trust because we, as an estate planning community, have determined that not all of you are going to do what you're supposed to do. So I'm going to tell you repeatedly to fund your trust and tell you how to do it and all that great stuff. And some of you are going to say, I don't want to do it. I don't want to have to go to the bank. There's a lot of forms. I don't know. I'll do it next week. And next week may never come. Or maybe you don't make it to next week. And then we have a problem because now we're right back in the same circumstance that we were in before we created the trust, which means we go through probate. So that pour-over will is going to help us take those assets through the probate process and put them into the trust where they should have been before we passed away. So we use this as a backup because we understand that sometimes not everything gets into the trust. Sometimes not anything gets into the trust, but really it's meant for just a few things that we forgot, if any. That's the most important part. All right, let's talk about unintentional probate estates. An unintentional probate estate occurs more often than you think, and it's usually because we as individuals want to try to put a Band-Aid on something that causes us concern, but we're not fully committed to fixing it the right way. Think a major surgery tomorrow, or I'm going on vacation next week, something like that. We're trying to make sure that if the unthinkable occurs, we have somebody who can access our assets or they can avoid probate. So we put someone on as a beneficiary who may not necessarily want to get our money or want to be able to access things, but because we are trying to solve a problem ourselves without really thinking it through, we end up with some undesirable consequences. I had a client come to me one time and she was really proud of herself and she said, I don't really need a trust because everything is beneficiary designated. And we went through everything and I said, you're right. You have equal beneficiaries between your son and your daughter on most of everything except this $325,000 account that's just got your daughter on it as a joint owner. She said, yeah, that was just, like if I get sick or something, I want her to be able to access the money. And I said, I understand that's what you think it's for, but that's not how it works. If you pass away as a joint owner, she gets it. She gets everything. There is no just because you were sick or it was only supposed to be paid for bills, et cetera, right? All that money is hers. She doesn't legally have to share it with anybody. And she may not. So your son is going to be out the chunk of that was you intended to go to him. I don't know that that's going to make them want to get together at Christmas, right? Because now she got all this extra money solely because she brought you to the bank that day and the banker suggested that you should add a joint owner on the account. And so you said, sounds good, you're with me, let's do it. Not always the result that we intend, right? So it is super important that when we're doing this, that we take into account the fact that that is estate planning. Adding beneficiary designations, making joint owners, you're doing estate planning with that. It may not be what you think of as estate planning, it may not involve your trust, but these pieces all have to fit together in order for them to work appropriately. I can put whatever I want in the trust. I can say that the cabin is gonna go to this person over here, and the grandkids are gonna get $5,000 for educational expenses, but if there's nothing in the trust and everything is beneficiary designated, nothing is going to the grandkids. They're not getting anything. And I can assure you that when people see that trust and they were entitled to something and they're not getting it because everything went to one daughter because she was at the bank that day, everyone is mad. Everyone is mad. And the daughter who went to the bank looks like a villain, even though she wasn't trying to be, because the plan didn't work. And that's what happens when we unintentionally do estate planning with beneficiary designations and probate and POD accounts. Okay, last thing I wanted to talk about was long-term care considerations. So the biggest thing that I see for people who come to see me is they come to see me and the money is going because of long-term care costs. It could be their own long-term care costs, it could be a spouse's long-term care costs, but it is a full-out panic, right? We are trying to figure out how to preserve the funds, and the estate plan that we came up with 5 or 10 years ago is not going to matter because there's not going to be a cent left to give to anybody at the burn rate we're going through, right? The other thing that happens frequently is that estate plan that you came up with 5 or 10 years ago is totally not the right plan for this stage of your life. The considerations and concerns you had when you're 65, 50, 40, 30, whatever it may be, are not the same considerations you're going to have when you're 85 or 90. They're just not. And our plans need to reflect that. The things that we're worried about when we're 85 or 90 are different than we were when you went on vacation and you wanted to make sure that there was a guardian name for the kids, right? We just are thinking about it differently. At this point, we're in a position potentially where we are facing exorbitant long-term care costs, and we're trying to figure out how we're going to make the money last and how we're going to make that work within the estate plan. What happens sometimes, especially when people come to me and we're trying to preserve assets or get someone qualified for Medicaid or just try to stop the bleeding, is that their estate planning that they did doesn't give me the tools I need to engage in asset protection planning later on in life. So I don't have gifting authority. We have a revocable living trust and not an irrevocable trust. We don't have the right players in the documents, or maybe we only appointed husband in the power of attorney and husband's incapacitated, and now we potentially are facing a guardianship. All of those things are problems and can lead to crises when we reach the long-term care planning stage, because we didn't really think about it, right? We went into it and we did our estate planning, and like I said at the beginning, we put those documents in a binder and we put them somewhere and we forgot all about them. I don't even know where they are, right? That's not going to help us when we get to this end stage in life. When it comes to paying for long-term care, which is a big concern for many people, there's 3 main ways that we pay for it. We can pay for it ourselves, we can self-fund, we can rely on long-term care insurance, and we can rely on government benefits like Medicaid or VA. It is important to think about this ahead of time. If we don't do any planning to figure out how we're going to pay for these things, then our choices become very restricted, right? Medicare does not pay for long-term care in assisted living, nursing home, supportive living facility. They pay for rehab. Okay? They pay for rehab in a nursing home or rehab facility to try to get you well enough to leave and go back to wherever you came from. They don't pay for long-term care. Medicaid pays for long-term care. Medicaid is a government benefit that is available to people who qualify. The qualification process is daunting. The state is asking for financial information going back a full 5 years before you apply. I don't know what you were doing 5 years ago, but what I was doing 5 years ago was not worrying about what I was doing with my money. And that's true for many people. They weren't keeping receipts of the time your daughter went to Kohl's and bought you a shirt, right? And you reimbursed her. Who cared? It doesn't matter. We just gave her some money and we went on with it. And it probably wasn't even the exact amount of money. But no one really thought about it because it wasn't something that we were worried about. And this happens all the time. And I can tell you that it is to your detriment if we are not doing some planning and thinking about what our long-term care situation is going to look like and how we're going to fund it, because if we're relying on government benefits, those come with some strings attached, and we need to be able to qualify for those benefits and make sure that we have the appropriate documentation and that we haven't made any gifts. And if we have made gifts, how are we going to handle those gifts? It is really important to plan for that ahead of time, otherwise we may not have the resources to offset any penalties we could get, and maybe we don't qualify for Medicaid. And that's an issue, right? Because which kid are you going to go live with if we don't qualify for Medicaid and the nursing home won't accept you? The other thing that people come to me and they say sometimes is that I don't want to go to any community. I want to stay at home. I want to stay at home forever. I want to die in my house, in my sleep. Don't we all, right? So it doesn't always work that way. And if it's not going to work that way, and you're not somebody where you're lucky enough to have that happen, then we need to figure out where you're going to potentially get care and who's going to do it. And sometimes we say our children are going to help us out. And sometimes they do, and a lot of times they don't. It is the quintessential family who comes to me, and everybody's in agreement, and they say, we're all just going to take shifts. We're all going to help mom out now that she's back at home. And it's usually one kid who's like trying to manage this. We got a schedule, they're really into it. And it's only up to that first weekend where brother's son has a travel baseball game where the whole thing falls apart, right? He didn't show up, and now one daughter is still having to do all the work, and everybody is upset, and the whole system falls apart. That's not always the best way to handle things. And it's important for us to be realistic about that, because if we're not, then we can end up in a bad position. The other thing to be realistic about is if we are at home and we need care and we want a caregiver to come and give us that care, whether it's you or a spouse, do you want to share your space with a caregiver? Not everybody does. Some of my clients say, I want a caregiver, and then when I say, okay, we're gonna do this, we're gonna have a caregiver come, they won't let the caregiver in, right? They say, I'm rethinking this. Now that it's actually happening, I don't want this person here every day. This is uncomfortable. I can't live my life. Or my spouse needs care, but I can't do my thing because we're all sitting on the couch tonight and watching Jeopardy together, right? This is not my idea of retirement. If that's not what we want, we need to be realistic about that, because then maybe staying at home isn't the best option, because sometimes that's going to involve having a caregiver come and sit on the couch with us and watch Jeopardy every night. So it's just important to really think about these things on the front end, otherwise we get into some crises mode, right? Okay, that's it for me. There'll be time for questions at the end, and now I'm going to let Kathleen take it away. We'll do questions at the end, so don't worry.
Thank you. Is this good? Good? Great. Okay, so hi everyone, I'm Kathleen Bolger with the Kenneth Young Center. I'm a social worker, so I'm going to talk about social workery type things. I'm going to focus on advanced directives, so healthcare powers of attorney and living wills. And I'd like to start by saying that these are legal documents. You can go to your lawyer and have them drawn up, but they are not legally binding. Okay? And what I mean by that is they are kind of drawn with a pretty broad brushstroke. You'll typically name an agent to act on your behalf, and you'll usually choose medical interventions that you do or do not want. But these documents are not going to cover every conceivable medical decision that will have to be made on your behalf, or that you might have to make on behalf of a loved one, right? They're very, very broad. And so they have a huge gray area. And I just want to show you briefly an example. So this is the Post. It's signed by a physician, it's signed by you, it's part of your medical record, it's a medical order. And in the box A, right, it's asking what you want to do if your heart stops, right? And so do you want cardiopulmonary resuscitation, yes or no? So you're choosing a medical intervention. In this middle section, that's for, well, your heart didn't stop, but there's some other medical emergency. What kind of treatment do you want? And that first choice is, I want everything. I want to stay alive. Give me whatever treatment you have. That's what I want. That's the treatment that I'm choosing. The third option is, well, you know, I want to die a natural death. I don't want artificial means, and I want to be kept comfortable. That's the treatment that I want. And then there's this middle ground, right? So I have medical conditions and I want to continue to get treated for those conditions, but I don't want any treatment that's overly aggressive, so I don't want any intubation or anything like that, so I just want the middle option, right? So I fill out my pulse and I choose the middle option. You know, I want to be treated for my medical conditions, but like I don't want to be like a Terry Schiavo type situation either. So I choose the middle option. And then the COVID pandemic hits, and it's, say, the first month, second month of COVID, and I get COVID, and I'm rushed to the emergency room, and the doctors say, well, we need to intubate you, except my pulse says no intubation, right? But what would happen if I could be intubated for a week or two, and then I would recover, and then in a couple of months, I would get my life back, and, you know, in that case, I would want an intubation. Right? So I don't think it's very helpful when you're putting together your advance directives and you're really thinking and planning. I don't think it's helpful to think in terms of the medical interventions that you do or do not want. But what I do think is helpful is to think in terms of function. And what I mean by function, think verb, think the things that you do in the world, the things that you do in your life that for you in this time and this place make life worth living. What are the things that you do that if you could no longer do them, maybe you'd rather not be here? What are the deal breakers for you, right? So this is a question of how you're functioning in the world, and it's a question of values, right? What do you value in the world? And I can think of no better story to illustrate this point than a story by Dr. Atul Gawande. He wrote a book called Being Mortal. It's on your resource list, and it'll be on my last slide here. And this is a book. It's about aging in the United States and the extent to which we do or do not care for our aging population. And in this book, he tells a very personal story about his father. His father was also a doctor. He was a surgeon. And he was practicing here, and he was a little, you know, getting up in years, but still working and playing tennis and all of that. And he developed a tumor, a cancerous tumor on his spine. And he started to get symptoms like tingling in his extremities. And so he talked to his doctors, and a surgeon came and talked to him and said, well, you know, this tumor is cancerous. We can't really treat it. We can't remove it. So this tumor will kill you. And before it kills you, you will be paralyzed. It will paralyze you. And there will come a time when you will need mechanical help to breathe and to eat, and you will need around-the-clock care. Okay. But we have this surgery. Let me tell you about the surgery, the doctors say. So we can't remove the tumor, but what we can do is kind of like make more space so that the tumor has room to grow kind of, and it won't put so much pressure on your nerves, and it'll reduce your symptoms. Okay, we can do that surgery. And his father said, well, what are the risks of the surgery? And they said, well, you're kind of getting up in years, so there's always a risk that, you know, your blood pressure could drop. I mean, there's always a risk of surgery. But also, this is surgery on your spine. So there is a pretty good probability that the surgery could leave you paralyzed. And so what his father said to himself was, well, I'm still working. I'm playing tennis. I'm driving. Like, I have some tingling. I am more afraid of what the surgery will do to me than what this tumor will do to me. So I am not going to have this surgery, thank you very much, but I will revisit the idea as my situation changes. And so some years go by, his symptoms get worse and worse, and now he can't grasp, he can't hardly walk, he can no longer work, he can no longer play tennis, he can no longer drive. So his abilities are becoming fewer and fewer, and his dependency on others is increasing. And so his son, the author of Being Mortal, said, Dad, maybe now is the time to consider that surgery again. And his father said, okay, let's talk about it. Now, the author, Dr. Gawande, he had learned a series of questions to ask from a palliative care specialist at Brigham and Women's Hospital in Boston. And he asked his father these questions. And the first question is, what do you understand your prognosis to be? And his father said, well, I understand that this tumor is terminal. I understand that I'm going to die from it. And I understand that before that happens, I'm going to be paralyzed. What are your concerns about what lies ahead? What are you most worried about? And his father said that he was most worried about being a burden to his wife and his family. He was terrified of that. What kinds of trade-offs would you be willing to make or not willing to make to try to stop what's happening to you? His father didn't really know how to answer that question, and so Dr. Gawande said, well, let me tell you a story about some other patient I know who also coincidentally had a tumor on his spine. And this guy said, you know what? You can give me any medical treatment. I can have to need help bathing. Will have to need help going to the toilet. I don't care. The only thing I care about is that I can sit in my chair, watch football on TV, and eat a bowl of chocolate ice cream. As long as I can do those things, my life is worth living. So Dad, how does that sound to you? And his dad said, oh, no, that would not be good enough for me. Well, what would be good enough for you? Well, he said, want to interact with people. I want to spend time with people. I want to visit with people. And so Dr. Gawande said, well, then, Dad, it sounds like you could tolerate paralysis as long as you can be surrounded by people. And his father said, well, no. I can't tolerate paralysis. I can't tolerate living with being intubated and a feeding tube. I can't tolerate being completely dependent on someone else. If that is what my life will be, please let me die. So his father, at this point, was more afraid of what the tumor was going to do to him than what the surgery might do to him. Okay? How do you want to spend your time if your health worsens? And his father said, well, I'd like to wrap up my volunteer activities and hand that over, and if at all possible, I'd like to travel back to India and visit family. And whom do you want to make decisions if you can't? And he said, well, I want you to make decisions and my wife, okay? So these questions are not questions about what medical intervention do you want, yes or no. But this is the kind of information that will be so helpful to you as a decision maker. And it will be so helpful to you as you're crafting your own plan. It's helpful for your loved ones to understand what is it for you that makes life worth living in this time and place, right? And you don't have to have a terminal illness to ask yourself these questions, right? Because none of us have a crystal ball. We don't know when our time is going to come. But in the event that it does come, you can ask yourself these kinds of questions and have discussions with them, with the people that you love. And these are not the only kinds of questions that you can ask. There are some other resources that can help you think through these questions. One of them is the 5 wishes, and there is a 5 wishes document in the bag that you will get when you leave. And this is recognized in Illinois. It is a living will, and it does have a framework. It's a set of questions for you to kind of think through what is important to you, what matters to you as you're going through the end of your life. And then there is an organization called the Conversation Project, and they have a number of different kinds of workbooks that you can download. We put one of them in your bag, but I don't think it's this one. And they are also frameworks of questions, so to help you start to think of this planning in terms of function rather than form, okay? They also have resources to help you have conversations with your loved ones who might be reluctant to have a conversation. They have resources for how to proceed when someone has dementia. So there are some really good resources here that I strongly urge you to start to just read through and think about. Think about how you want to function in the world. That's much more helpful than only thinking about the medical interventions that you want. So, why is this important? Lauren touched on some of these, but obviously medical professionals need to know who your agent is, who has the authority to make decisions for you. It can save your family from legal battles, right? You know, you get married, second marriage, and you have all separate finances, and you never signed a financial power of attorney, and then your husband has a stroke and he has vascular dementia, and you have to hire help at home, and you can't access his money except through going to petition the court for guardianship. Huge hassle and very costly, right? Do your loved ones a favor and get your financial power of attorney and healthcare powers of attorney documents signed. Also, having these documents signed and doing this work, the work of figuring out what your values are, what matters to you, it really can increase the likelihood that you have some peace and control over your situation. And there was some excellent research done in a research, I think it was called the Cancer Project, and they looked at this population of people who had terminal cancer. And they knew after the fact, within like 4 months of these people finally dying. And a third of these patients had conversations like those questions that I just showed you. They had conversations with their doctors. And 2/3 of the patients did not have these kinds of conversations with their doctors. And the third of the patients who had these conversations, they were far less likely to be intubated. They were far more likely to be conscious, awake, and able to interact with their loved ones. They were far less likely to end up in the ICU. And at the 6-month mark, 6 months after all of these patients died, the patients that had the conversations with their doctors about their values, their families reported a statistically and clinically significant reduction or less of an incidence of rates of depression, right? So these kinds of conversations are so important. They're so important to have with your loved ones. They're so important to have with your medical professionals. it will really give you some control over your situation. And also, having these conversations and having your legal documents in place will spare your loved ones potentially from conflict and anguish, right? So you're a mother and you have a couple of terminal problems. You have end-stage renal disease and you have a cancer. And you are with one of your two daughters and something happens and you have to go to the emergency room. And on your way to the emergency room, your daughter's with you and you say to her, I don't want to die like Dad died in a hospital hooked up to machines. And that's the only conversation that ever was had, right? And there are no healthcare power of attorney or advance directives, right? That's the only sentence this person ever uttered. So you lose consciousness. You're in the emergency room, your other daughter shows up, so here they are, and the doctors say to the daughters, hey, we need your permission. We have to intubate, and we have to put in a feeding tube, and we have to put her on a dialysis machine, or she's gonna die. And the daughter says, well, my mom didn't want to die in a hospital hooked up to machines, so no. And the other daughter says, well, she never told me that. In fact, I think you're probably just exhausted from taking care of her. So of course, that's the answer that you would give. But I have to tell you, if we don't authorize this treatment, we're gonna be responsible for her death. Okay? And that's a very real thing, right? When you have to make a life or death decision, that can be anguishing. So save your family the anguish, or your friends, or whoever it is who's going to make a decision. And give them instructions, give them the information they need so that they can make these decisions with a fair amount of confidence and not so much anguish. Okay, so great, Mom and Dad, do you have the healthcare power of attorney, financial power of attorney? Do you have them? Where are they stored? Like, we should talk about this, shouldn't we? And then your mom says, ugh, can't we please talk about something more pleasant, right? Which is a book, it's a graphic novel by Roz Chast. This book is hilarious, and it is very honest and true, and it's her experience of taking care of her parents as they age. You say to your husband, hey, we're 65 years old, not getting any younger, maybe we should get our act together, and your husband's like, I don't want to talk about it, right? So what do you do then? What do you do? Well, one thing I recommend is to try to approach it like a family sort of activity, right? So let's say you're the daughter, and so you're gonna gather the 5 wishes documents, and you are gonna fill it out for yourself. And you're gonna call up your family and you're gonna say, hey, I have a worry that in the unlikely event something should happen to me where I can no longer make a medical decision, I'm really worried of losing control over what happens to my body. And I know one of you are gonna be the person who's making decisions for my care, so I want you to know what's important to me. So let's sit down and have a family meeting, because also it's important for me that I know what you want, right? Blah, blah, blah. So you bring your 5 wishes and you're all sitting around the table, hunky-dory, and you're reading through the questions and having discussion. So that could happen. Maybe it won't. Maybe your people are like, I am not gonna fill out these documents. So if that's the case, you fill out the document for yourself. And by the way, you just have to be 18 years old or older. Like, everybody, in my opinion, as a social worker, should have a document like this completed. We should all be thinking about what's important to us and what matters in the event that we can't, right? So you do this work for yourself and you call up your family and you say, hey, I have a worry in the unlikely event that I can't make decisions for myself and you're gonna make decisions. I need to explain to you what's important to me so that I can have some control over my body. You go over there and you go through your document and you go through your decisions and you can say, yeah, so Mom, what do you think about that? Like, this is what I decided, what do you think about it? Or Dad, I don't know, what would you want if you were in that situation? So even if your loved ones are not gonna complete a healthcare power of attorney, if they're not gonna go through documents like the 5 wishes, you can still get some of the information that you will need when the time comes that you have to make decisions for them, okay? The other thing you can do is try to bring it up when it kind of naturally arises. So you're home with your husband and you're watching reruns of ER, that TV show from the 1990s and 2000, and oh, there's a situation where a family is having a conflict over intubation, yada, yada, yada. So you can say, hey, if that were me there, I just want you to know that I am not ready to leave this earth. I want every conceivable medical intervention possible. I am telling this to you now. By the way, what would you want if that were you, right? Find ways. Oh, the neighbor, it was awful. He died in the hospital and it was da-da-da-da-da. I really would not want that for myself. Well, what do you think? Right? Find ways to learn what matters to your loved one. Okay, I just want to say a quick word about dementia, right? And Lauren talked about this also. If your loved one has dementia, that does not mean that they cannot participate in their care. It does not mean that they don't have capacity necessarily to make their needs known, okay? Someone who is in the early stages of dementia, they know what is happening. Even if they kind of deny it, they know something is not right. And that can be a motivating factor in getting someone to sort of get their affairs in order and let them state what they want for their body before time runs out. They certainly have language, they can certainly express themselves, absolutely. Someone in a middle stage of dementia, they may really struggle with language, they may not use the right word, or they may really search for words. They may have really very limited language skills, but they certainly can express themselves, with body language, absolutely, right? So even someone in a middle stage of dementia, as long as you speak to them in short sentences and you ask them questions that are in a yes or no format. Don't ask an open-ended question. Don't speak like I'm speaking in all these sentences. Keep it very simple. And try to take advantage of the fact that many, many people in a middle stage of dementia, they will retain long-term memories, but they won't remember what they ate for lunch. So maybe they would remember the Terry Schiavo case, possibly. And you could sort of test the waters. Oh yeah, we were talking at work about the Terry Schiavo case. Do you remember that? It was da-da-da-da-da. I wouldn't want to end up like that. What about you? Yes or no, right? Or what about our neighbor, Susie? This thing happened to her. I wouldn't want that to happen to me. What about you? Yes or no, okay? Now, when someone is in a later stage of dementia, they will not have language, they will not understand consequences of decisions, they will not have capacity, right? So what do you do then in the absence of any kind of conversation that you might have had with them or any kind of advance directive? Well, I have a couple of suggestions. You need to think about your relationship with this person. Let's say it's a parent, right? And think back through their lives. And do you ever recall a time when they might have talked about someone else who was having a medical condition? Like, would they be the kind of person who would worry maybe about being neglected from the healthcare system and not getting enough care? Or would they be the kind of person who would worry about getting overly aggressive care? You may not know the answer to that, but if you think through your memories of this person, you might be able to answer this. Secondly, would they be okay spending the last days in the hospital? So are they the kind of person, did they ever express an opinion about the hospital? I remember when Mom, that time that she was in the hospital, she really seemed to like it. Like, she really liked the food, and she felt like all these people were caring for her. Like, she really seemed to like it. Whereas Dad, after his hip replacement, he could not get the heck out of the hospital fast enough, right? Would they be okay spending their last days in a hospital? So what have they expressed worry about especially, right? Mom, you know, she just always said that she wanted to make it to Johnny's graduation in May. Or Dad, you know, he was so fiercely independent. Oh my goodness, like he just could not bring himself to ask anyone for help. And in fact, he was a little contemptuous of like the neighbor who was always asking him to help fix his lawnmower. He just prided himself on being self-sufficient. And so if he needed help to use the toilet or to bathe, I just think that would be the most deeply humiliating thing for him, right? That's how you can begin to kind of construct what you believe the values are of someone who can no longer speak for themselves. Okay, so the first suggestion that I would like you to take away is that if you don't have your documents together, please start now. Just start now. Just start now. Don't think about it. Just start now. If you did your documents, maybe 10 or 15 years went by, now would be the time to get them back out and see if maybe you need to make revisions. Maybe your proxy is no longer alive. Maybe your proxy moved so far away that it's not practical that they're a decision maker for you. Figure out what matters to you, think in terms of function, and then have the conversation with your loved ones. Have the conversation with your medical professionals. Have this conversation early and have this conversation often. If you have a pulse, put it on your refrigerator, right? You call EMS when you're home and they're not gonna, you know, sift through your healthcare power of attorney, I promise you that, but they do know to look on a refrigerator. Okay, so you store your originals in a safe place. A lot of lawyers will store your originals. Put them in a safe deposit box. Put them in a, you know, fireproof safe. Make copies and give copies to your proxies. And, you know, maybe to avoid conflict, you can give your documents to other family members too. That way everyone kind of knows what the situation is. Oh, and give, especially if it's a post or something like that, to your medical professionals. And keep a list of the people that you give the documents to. Keep a list of the people that you give your documents to. The name, the contact information, the date that you gave them the document, and the name and the date of the document. So this is my healthcare power of attorney dated October 1st, 2023. And then if and when you update those documents, you whip out your contact list, you call these people and say, I have a new document, please rip up that document, here's my new document. And you update your list with the name, the contact information, the date you gave them the new document, and the name of the new document. This is my healthcare power of attorney, signed October 1st, 2030, okay? And you can give copies of your list to your proxies too, so they know who has the copies of your documents. Yeah. Okay, so when to get your documents in order? Now. And I'd just like to say a word about inertia. This is another kind of obstacle, but it comes psychologically from within, right? You may be the kind of person, like, you're single, you don't have children, and you have no idea who to name as your proxy. You don't know who to name, so I'll just do it later, right? Or I don't know whom to choose. Should I choose my daughter? Should I choose my husband? It's gonna cause conflict, I'll just do it later, right? Or I really don't know enough right now. I don't feel confident to get these documents together. I have to do research. And I have to figure out, am I gonna use the 5 wishes or the conversation project? And then I have to do the 5 wishes and the conversation project. And then I have to research what lawyer I'm gonna find. And then I have to make an appointment. And so I'll just do it later, right? And I'll do it later, it turns into months, and it can turn into years of nothing, but I'll do it later. But later, it never comes, right? So if not later, then when? And that concludes my presentation. Thank you so much for coming. Oh. I know where it is. I can't like see it. Can you see it? Yeah.
I got it. Okay, thank you to both of our presenters. I have a couple of questions here written down. I don't know if anybody else has any written down, or we can do some verbally. I'm going to read these two, and I'll probably need Lauren to help me answer them. The first one is, if my trust allows my daughter to inherit money and she dies before me and it was not changed, does the money go to her husband or to her children?
I think this works, actually. Good question. So it doesn't necessarily go to her husband. It most likely goes to her children, but you'd have to actually look at the document itself. The default is usually that it goes what we call per stirpes. Per stirpes means to your lineal relatives, like your bloodline. So if you gave the money to your daughter and then you said per stirpes, it would go to your daughter's children, grandchildren, so on and so forth, as opposed to a spouse.
Okay, great. This question came to the library's email. It says, if I have Medicare with Medicaid as a secondary coverage, would Medicaid attempt to recover costs from my heirs? And she clarified it with, not the spend down Medicaid for long-term care, only the Medicaid that is secondary for medical bills covered by Medicare.
So, without knowing exactly what type of Medicaid program she has, it's a little tough, but I would say from your heirs, not necessarily. From your estate, possibly. So it depends on how you go forth and put together an estate plan. If you do nothing and your assets, that let's say it's real estate, that ends up going through probate process, then the state can, for certain types of medical Medicaid, put a lien or file a claim in a probate court. So we want to try to avoid that if at all possible. It really depends on what sorts of services that you're receiving.
Great. Does anybody have any other questions they'd like to ask verbally? Go ahead.
So if you have a healthcare power of attorney and you named an agent, you're in an accident, you get taken to the hospital has no idea that you have that document, your agent has no idea that this is going on, so it comes into play that they have to make a decision. Why is there not a database that says, this is this person, this is their documents, so why does this rely on a physical piece of paper?
Yeah. I would say that from a, basically a financial perspective, nobody really wants to manage that. That's why. The reality is that it's a lovely idea. I think that there's some practical considerations, but the best way to avoid the circumstances that you're describing would be that you give a copy of that POA to all the agents, right? So that if someone does get a call or your agent does hear that you're in the hospital, they have the document. They're not hunting around your house at 2 a.m. to try to, figure out where that binder is. And most importantly, most hospital systems and doctors and networks have some sort of portal, right, where you can upload things and you get information from the doctor and then you can give the doctor information. So you should have the ability to upload POAs to that portal so that when you do go to the hospital or in that system, they will know that you have a POA. Is this perfect? No, but it is better than nothing, and this is what we have right now. And so you have the opportunity to give that document to your doctor, which you should, your primary physician, and then also upload it in a portal or something like that.
So if you're out of state, would they have access to that?
If you're out of state, would your doctor have access to it? Yes. Whether or not the healthcare system would is kind of a separate issue, right?
Yeah.
But
They would have to know who your doctor is in order to contact your doctor.
Agreed. At that point, they would also need to know who you are. And if you're out of state driving around getting an accident, maybe that's our first problem.
So there used to be a recommendation that you put in an ICE number on your phone in case of emergency. I don't even know how you would get to that if your phone's locked.
Yeah. No, I mean, yeah, the best case scenario is don't ever travel. No, I'm just kidding. You're gonna go places, you're gonna have, your documents and things like that. The hospitals, they can't really do anything except keep you alive,
Right.
Their job is to keep you alive. So no crazy decisions are being made until they find somebody with authority to make them.
Can you have like a emergency card in your wallet to say an emergency contact someone in your friend's family?
You can. I'll speak as a long-term ER nurse here. You can have a card in your wallet. It is not the first place that we're going to look, but yeah, if you're out of state and we don't know who you are or who your doctor is, the first thing we're going to do is keep you alive. And then later, when things calm down and things get found out who's who and what's what, then we let your POA make decisions for you as time goes on. But initially, we're going to keep you alive. Yeah. Go ahead, sir, in the green shirt.
You had touched on the fact that we all have to worry about long-term health care costs, and you mentioned Medicaid, but aside from these extremely expensive insurance policies, is there any way to prepare for that?
Yeah. So there are a lot of ways to prepare. Some of it depends on how far in advance you do some planning, and then the other piece of this is also people have different circumstances and different goals. So sometimes people come to me and they say, I'm younger, but everyone in my family has had dementia at relatively young ages or at some point. And so I want to take steps to make sure that if and when that happens to me, I have done something to preserve my assets so that I have money to rely on and that I can qualify for government benefits and that I leave money to my heirs. Not everybody is in a position to be thinking that forward, right? And so that is where things kind of fall apart. But sure, there's definitely things we can do. A lot of them come into play when people are in crisis and we say there's a cost right now. We have a very expensive nursing home that we're trying to pay for. How are we going to stop the bleeding? And we can still do things. Elder law attorneys can still help you in that case. We just can't save as much money as if we were really planning it out. But yeah, there's trusts. There's a million different exceptions under the Medicaid rules that we could spend hours talking about.
Ma'am?
Let's say you don't have a trust, but you have a will.
Mhm.
So as you mentioned, it has to go through probate
Mhm.
in order for the judge to say, okay, you can sign document. Now, is the judge required to follow what the person who was deceased has written in the will? Like say they are named an executor.
Sure.
Is the judge required to grant that power to the executor, or the judge could decide in any way they like?
The judge can't decide any way they like. They have to follow the order. So let's say the executor says, I don't want to act. So let's say it's a family member who was not named in the will, but they're a beneficiary, and they say, somebody's got to be the executor, and I want my money. And the executor says, I don't want to do this. This is too much work. I'm not getting anything. I don't want to do it. The judge could go down the list, and all those people who were named would have to decline before we'd appoint somebody else. But that's certainly possible. The judge can't say, this person has come in and I just don't like them. They're annoying me in court today, because judges get annoyed easily. If they're annoying me in court today, I don't want to appoint them, and so I'm going to appoint somebody else. It doesn't work that way. They have to follow your wishes in the document, and only then can they say, all right, well, everybody cannot act for whatever reason. In that case, then they could go through, the probate code would say, these are people who could act. These are the people in a different order who could act. So parents, spouses, children, cousins, there's a whole list of people who could end up acting.
But the person who was named in that document, do they have to be in the United States, and do they need to have a social security number?
So they don't necessarily have to be a U.S. citizen with a social security number. I would say from a logistics perspective, it makes it a lot more complicated, because depending on whether or not there is a bond requirement, that may be really complicated, because in probate, if you don't have a will or if you don't waive the bond requirement, then you have to get a bond to ensure that you as executor don't run away with the assets. The courts don't like that. And so you do have to have a social security number to fill out the bond paperwork. That's the only time I could think of where you would need a social security number, and that may be complicated. I'm sure there's a way around it, though.
Okay, has a social security number there, but the money, the executive has to give it to the
The
people,
beneficiaries?
non-beneficiary. They are not in the US and they don't.
That happens. That's fine.
That's fine.
Mhm.
Okay, thank you.
Mhm.
Go ahead, Denise.
Can a lawyer be a power of attorney? The power that I had on my will, a person passed away.
Yeah.
I need to get a new, but when I look around, I have no family left. And I look at my friends, they're both mostly my age. Better to have somebody than nobody, but I'm really hesitant what to do.
Yeah.
Other resources?
There are other resources. I'm not a good fit, so I'm really not. I'm really good at what I do, but I'm not necessarily making your life decisions. So there's people who are much better suited for that. There's geriatric care managers, there's patient advocates, there's actual daily money managers. I have a whole list of people who I would say, depending on what you need and where you live.
I mean, you'd like to have somebody personal,
Yeah.
family, whatever. But
Sometimes.
if you don't have that, there's gotta be
Yeah.
a resource.
There's actual companies that solely exist to serve that void, to fill that need.
And they charge to do it.
They do.
Go ahead, ma'am.
I have a question regarding, you said you have to have a will and a trust? Okay, you can't just have a trust.
Well, you could, but
You don't
if,
recommend that.
yeah, you don't really want to
Okay,
do that.
and if I were to do a trust here in Illinois and I moved to Florida,
Mhm.
is my trust still mine?
It is still valid. Sometimes we want to update it to Florida law, so if there was an issue, then you're not having a Florida court make rules and decisions based on Illinois law, which is kind of awkward, but it's not like the end of the world by any stretch.
Okay, and I just want to make sure I heard you. If you only have a will and you don't have a will at all when
Mhm.
you die, your husband would get half and your children would get half?
Yes.
Yes.
I mean, like in my circumstance, because I'm married and have children, yes.
Okay.
But if that wasn't the case, then there's a whole hierarchy within the probate code that says
What about
who gets what.
stepchildren?
Stepchildren are not legal children under, the law.
Anybody else? Yes. Go ahead.
Is there any idea what wills and trusts cost?
Yeah, this was the question earlier too. It's a good one. Yeah, so I can tell you what we charge. I can't really tell you what everybody charges. I can tell you that the basic rate for our revocable living trust is between $3,000 and $4,000. For wills, it's usually closer to $2,000. If we're getting fancy and we have tax issues or irrevocable trust planning and Medicaid planning and things like that, then it's a little bit more expensive after the revocable living trust.
Go ahead.
What if you can't find the original documents, either the trust or the will, but somebody, for instance, what if the person had the original, but the attorney has a copy? If it's not the original, are we out of luck?
No, so you can get by with copies for everything except the will. And there's a caveat to that. So we can get by with a copy of the will too. It's more of a pain to have to do that. So I would say search high and low on the will. But with regard to everything else, a copy is fine.
Did you have a follow-up?
I had a separate one or something else.
Go ahead.
Who decides if somebody has the capacity to make changes to their will or not? And you were talking about people have different levels of capacity. My father wants to make a change. I'm concerned we need to make the change before he gets too far. Who decides when it's too far? Is it the
Yeah.
attorney who's processing the change? They're uncomfortable with it, or?
Yeah, usually. I mean, so the point of making estate planning documents and making those changes is we want that to hold up, right? So if I make changes for somebody who's incapacitated down the road, people who maybe don't like those changes are going to say, he was incapacitated. The old version should stand. This wasn't okay because he didn't know what he was doing. That doesn't really help anybody. So as an attorney, if somebody is questionable or there's already a diagnosis of dementia, we usually get a doctor's letter to say this person does have capacity enough to execute documents, because I want whatever I do to be, valid. I don't want the other people who don't like it down the road to have a contest, we end up in court, right, arguing about whether or not the person was really had capacity that day.
Yes, ma'am.
I It doesn't have to be my own children.
No.
Suppose if I want to give it to my nephew, I can
Yeah.
do that. But in the trust that I create, can I, will there be any conflict of interest issue that might arise if I'm making that person the executor of the trust and I also name that person to get the wealth?
No, there's not necessarily a conflict of interest. Many people are the trustees or executors, and they are also beneficiaries, because when we look at our pool of people, they're the most likely candidates. So it's not necessarily a conflict of interest. The only time it's a problem is if, for instance, the trustee was doing something to benefit him or herself with the assets, but that's a problem even if they weren't a beneficiary. So.
So the won't, and the children cannot go fight over it as long as you're clearly specified in the trust.
Anyone can fight over anything, and that's why we have jobs, right, as attorneys. Anyone can fight over everything, and frequently people do. Whether or not they're going to win is a separate issue.
Okay. So even after knowing that they are not in the trust, they could still go and fight over it.
Yep.
But is the judge required to honor that person who's going to fight?
That depends on the facts, right? So if you lack capacity at the time, then maybe.
Yes, ma'am.
I have a question. I just asked actually my POA for medical, who happens to be a nurse. And I said, can I upload my POA and my financial POA to my patient portal? If so, can Alexian, because that's my hospital, have access to my portal? Because my doctor's affiliated, but when you're in the hospital, your doctor isn't give you the hospital list. So what happens?
Well, if you upload a healthcare POA to the portal, then the hospitalist in that network, right, they would have access to that. Well, they should, right? They should, because they would have. Let's put it this way: if I went to Lutheran General and they looked at my name in their system, they would see the records that they have for me based on whatever times I was there. And if Advocate, which is part of Lutheran General, saw documents from a healthcare POA or messages or whatever it may be, that's all part of their system that they can view. So if my healthcare POA is there, then that's a win.
Yes, sir.
You have a will, and you want to revise it, but you want to use a different attorney. What happens to the original attorney who did the original will? Does he have to be part of the group? Or?
They get really angry and they chase you. No, they don't have to be part of anything. They, you can switch attorneys left and right. It happens all the time.
Go ahead, sir.
What would it cost to revise a will or a trust?
That depends on what kind of revisions you want. Sometimes we can do something really simply like an amendment, but sometimes we have to restate the document, and that's more complicated based on what you want to change.
Any other questions? Yes.
How do the trustee and executor know what they need to do as trustee and executor?
Usually they should consult with an attorney after someone passes to go through that process. That's your best bet, because there are certain things that you might have to do. I mean, definitely if it's an executor, you have to consult with an attorney to go through the probate process. So that's really your first step.
Does it have to be the deceased person's attorney or
No.
can it be anyone?
Any attorney.
Not full of paper.
How we doing? One more? Yeah?
How much is the power of attorney cost?
Yeah. If it's just powers of attorney, those are usually like $500 to get those done.
Thank you.
Any more? Oh, okay.
I just want to make a comment that this has been excellent, and I've really appreciated all the information you've said. It's so important to have the conversations with your loved one. We were in a situation where my dad went into the hospital for a routine cataract operation, was not doing well. They admitted him to the hospital, and in one day's time, the doctor said, your dad is in acute myeloid leukemia. He has 2 months to live.
15 minutes, I mean, sometimes it was emotional because you never want to lose those you love. But the gift that my parents gave my brother, my sister, and I was incredible. Because that night, we knew exactly what my dad wanted. We knew exactly, you know what I mean, his wishes, everything was in order, everything. And so I just can't stress enough, even if it's uncomfortable, to have the conversations with the people that you love and your family. Because it really, really was incredible. We never thought we were gonna be in that situation at all.
Yeah.
So in all of this is so important, but to have the conversations so that you're not caught, you know what I mean, in
Yeah.
crisis. I just wanted to share that.
Thank you. Okay, we're gonna draw for the raffle. We have 3 raffle prizes. Okay, last 3 numbers on the ticket are 156. Anybody? 156? No?